Will you hand me my screen mops?
Okay, so we are going on the record in the matter of Erica Bohn 23910A and appearance counsel.
Good morning, Your Honor. Christopher Shepke appearing on behalf of my client, citing to the matter being heard via Zoom.
All right, thank you. And Ms. Bohn, your name please for the record.
Erica Bohn.
All right, well, you were sentenced on June 6th. You're on probation for operating on visibly impaired. It's alleged that you failed to register for drug testing.
Yes, ma'am.
Hold on, ma'am. And counsel as to this matter.
Your Honor, we will not be requesting a violation probation hearing.
All right, and counsel, I'm sorry, and ma'am, as to the allegation, how do you plead?
This would be guilty because you're admitting that you failed, and I'll have an opportunity to speak on your behalf. So
okay.
As to this question, how do you plead?
Guilty, ma'am.
And you also understand the possible recommendation and the possible penalty, including the recommendation for you to continue to complete all terms of probation, pay a $50 probation violation fee, increase testing, 30 days on the alcohol tether, and mandatory jail for any future violations. Do you understand that?
I do.
All right, counsel, you can please pardon your client.
Yes. Did you fail to register for drug testing as ordered by probation?
I did.
Satisfied, Your Honor.
All right, the court has also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation, indicate technical violation number 1 based upon your plea of guilty. And counsel?
Judge, I'd ask for a deviation from the recommendation. It does seem a little bit aggressive. This is not a scenario where my client tested positive for drugs and alcohol. In fact, she is eager to provide a sample to the court to show that she is maintaining her sobriety. She found herself in a unique position where financially she was struggling. However, she is going to be in a position to get fully registered within the next 48 hours and then obviously comply with any terms and conditions. Judge, I'd ask at this point potentially that any sentencing be momentarily suspended to verify the results of my client's testing. At the most, Judge, I'd ask that potentially she has to pay the $50 fine for the inconvenience of having to come to court. But I do ask that sentencing be momentarily suspended to verify my client's sobriety. And if she is in fact clean, as she indicates, that this would be her first and only violation in her probation. Thank you, Judge.
Okay, so here's what's troubling is I'm not really sure, and I have to figure out why it took so long for this to come before the court. I have to double check that out because you've been on probation since June and you've gone 4 months without any testing.
Yes, I was just told to at the very end of October when I went to see Marcy. She let me know I would begin testing. That she did not tell me, and I was not aware of any testing. She wasn't aware I was supposed to be tested. It was not in my packet. So she just told me at the very end of October. My son has been suspended for the last 10 days. I have been at home with him. I just started a new job.
Hold on, please. Hold on. So I will note that at the time you were sentenced, it was when one probation officer left and then Marcy began her position. So I will note that. However, you're telling this court that when you received your instructions, you didn't have anything regarding testing.
No, ma'am, I did not. And they did not tell me to, and they were not aware I was to drug test.
Yeah, I don't believe that that's accurate. You were given that information twice.
I was not told to drug test until Marcy told me at the end of October.
Ma'am, you received information, you received written instructions, did you not?
Yes, there was nothing about, there was something that says I could be submitted to random drug testing, but there was nothing in writing that I was to. And I was not told about submitting until the end of October.
Ma'am, this court ordered you for random testing, okay? So the paperwork that you indicated or that you received that states you could be submitted to random testing, right? Is that what that says?
Yes, I could be, yes. And they did not tell me that I was to. I did not get one of the papers that they just gave me for the drug testing. I never received one of those. I just now got it, ma'am, and I'm just now getting new employment in order to pay my probation fees and these new fees that I'm accruing for the tests. I did lose my other job. My uncle passed away that I was working with. I've just
What's your new job?
the Dollar Tree on Fort Street in Emmons in Lincoln Park.
So here's what I'm going to do, ma'am. If you're tested right now, what's in your system?
Nothing but the prescriptions I am supposed to take.
And does probation have a copy of those prescriptions?
Actually, I have them in the car. I can go out and get them and bring them in for her.
Okay, that doesn't answer my question.
No, she doesn't. She doesn't because I wasn't told that I was supposed to drug test. So why would I give her my prescriptions when I wasn't drug testing?
Okay, ma'am. You're going to go get those you're going to go get those prescriptions.
Sure.
You're going to give those over to probation right now, and you're going to go test today.
Okay, no problem.
And then we will set this for sentencing November 13th at 10 a.m.
All right. Thank you, Judge.
Okay, do that right now, please, ma'am, and then we'll see you back on Monday. So the court will order a $5,000 personal bond. We'll see you back on Monday. Stop over and see Marcy. Thank you.
The court will call the matters of Brian Holly, case numbers 21S00163, 21T00282, 22S00523, and 23S00528.
Paul Barnett on behalf of the township.
Good morning, Your Honor. Assistant Public Defender Jay Bellinger on behalf of Mr. Holly, who appears to be assumed from the jail. Mr. Holly, can you please state your name for the record?
Yes, Brian Holly.
Good morning, Mr. Holly. Good morning, Mr. Barnett and Mr. Bellinger.
Good morning.
Good morning, Your Honor.
Your Honor,
Go ahead.
it's my understanding we're here for pretrials this morning. I made a late discovery, unfortunately, that we didn't have the correct discovery for the telecommunication services case. When I'd spoken with Mr. Holly, we'd been talking about global resolutions. We hadn't looked at that case in particular. I have made the request to get that corrected this morning, and that is being sent over, is my understanding, so that we can review that. So we would be asking for an adjournment on these matters. This would allow for more conversation, hopefully for a global resolution. And I would ask to address Bond at the appropriate time as well.
You may at this time.
Thank you. Mr. Holly is in on a $25,000 bond. He's been in for some time now. He has some pretty heavy family stuff going on right now. We would be asking for the court's consideration for a GPS tether in lieu of him remaining in jail. He'd like to get out. He'd like to start working. He'd like to be able to prove to the court that he's capable of being out without absconding. He understands that the court considers him to be a flight risk, considering the 2 years that went by where he was absconding. That said, it has been a minute now that he's been in jail. He does take these matters very seriously, and he does wish to remain and challenge them. He's been in this community for 20 years in this general location, and so he's not going anywhere.
Thank you, Mr. Barnett.
Your Honor, I'll leave it in your discretion ultimately, but this is a rather old case. I believe he didn't appear at a final settlement conference. The allegations in the case are that there was a crash and a blood alcohol level of 0.221.
Your Honor, if I may respond on behalf of the state. You may. As Your Honor called, Mr. Holly is here on 4 cases. 2 of those are the older ones, which are the child abuse case from the state, as well as the high VAC case from Mr. Barnett that he just discussed. When Mr. Holly absconded, it was the combination of him not testing, or I believe after testing positive, but not testing at all, as well as not showing up. The subsequent two cases that we have from Mr. Holly are another child abuse related allegation, as well as malicious use of telecommunications with Ms. Christine Hickman, mother of those children. The last time we were here at the pretrial, I mentioned that Mr. Holly had made some calls from jail, specifically instructing Ms. Hickman not to come to court and participate. And she apparently changed her mind about what she planned to do, even regardless of her intentions for planning to come to court. After that conversation, I did indicate that I would be looking further into that to find out if there was enough to substantiate a felony charge, and I would certainly be proceeding with that if there was. Mr. Holly has continued to contact the people he's not supposed to have contact with after that hearing. In fact, discussing on one of those calls the fact that we brought this up in court and that I heard those calls previously. Mr. Holly currently has a no contact order with Ms. Hickman and with all of the children, given that there are direct allegations involving each one of those parties. We have since spoken to them. And also had a call with another individual where he made it very plain that he was not going to not only plead to anything, which he certainly has a right. Mr. Holly can exercise his full right to have a jury trial on each one of these four cases. But he mentioned that he was not pleading to anything and he was not going to be on anybody's tether whatsoever. He said that he was going to leave that jail with nothing. He was going to stop drinking if he decided to do so on his own terms. So given the fact that there are continuous bond violations that not only reflect upon no contact orders, and the fact that Mr. Holly, I understand, is eager to get back to his family and work out his problems on his own terms. But right now, the allegations are against every member of that family, and we're still violating no contact orders. Alcohol is an issue in each one of these cases as well. I don't see why continuous violations of bond would merit any sort of favors in a release to continue doing so. I don't know what has been provided to the court or to the people or to Mr. Barnett that would be any reassurance that all of this is going to change if we reward that behavior.
Thank you.
Your Honor, can I say something?
You may not. I think you said enough in your phone calls, don't you?
I just would like to say that it's imperative, Your Honor. I'm just concerned about my children. The case with my son, he's now locked up in a juvenile facility across the street, Your Honor. He was caught with a loaded gun. I apologize. I know I went against the code of the court, and I'm truly sorry about that. But one thing I would like to make the court aware of is that I love my children, Your Honor, and I'm scared for him. I'm scared for my children. I know I made mistakes, and I'm here not to go against nothing you guys are saying. I'm here specifically to take accountability for what I have done. The reason I have talked to my children, to talk to their mother, is strictly based on caring and being concerned about them. I've been in here 31 days, Your Honor. I've had no sleep. I've been very stressed about and worrying about my child. Now the situation that happened, I'm not gonna go too far in detail because I know this is not the time. Parent tells child to do right in school. Listen to the teacher. Do what you're supposed to. Don't get in trouble. The reply he says is, F you, I do what I want. I say, give me your phone. Go in your room. He goes to the room. He gets another phone. He calls the police.
All right, Mr. Holly, you're treading here.
I'm just trying to.
I know.
I'm gonna make this short because she's giving me an opportunity to speak.
Actually, I didn't. You did exactly what I said.
I'm sorry, ma'am. I'm hearing all this, and it hurts. It hurts to even hear these allegations put on me. I'm a parent, and I know I have not made all the corrective choices, but I just want the court to know. That it sounds bad, but I love my children. I will never hurt them. I'm just guilty of not knowing what to do at times. I'm a hardworking citizen. I've been around this county for 20 years. I work. I do what I'm supposed to do. I have not committed any atrocities in terms of crimes. I've made mistakes. Your Honor, and I'm accepting accountability for that. I promise you I am. But what I'm not is a threat to society. I'm not a threat to the world, and I'm definitely not a threat to my children. But what I do know is that my son was just put in a juvenile facility. He's on probation, Your Honor. He has a GPS teller on his leg right now. He's only 13, and he was just caught with a loaded pistol. This is what I was trying to prevent. And in doing so, I was lied on and said that I
Hey, Mr. Holly, careful, you're treading here again.
Okay, I'm done. I'm sorry, Your Honor. I'm sorry, but I just feel these allegations is making me look brutally bad when I know I made mistakes. I'm taking accountability for this. But I promise you, I just want to be out to do a better job in raising my children so I can move on with my life. I would accept any stipulation that the prosecutor agreed to, a teller, an alcohol monitor, anything, and I will abide by that. And I promise you I will. I just feel like I have such more duties out there than I do in here. And I know I'm a contribute to the world, not being in here. And I just want an opportunity to prove that. And if you guys can just give me another chance, I promise you I will abide by any stipulation that's given by the court.
Sir, all you've proven to me so far is you will not follow any of my orders or directions at all. I told you not to speak, and now you've been speaking for about
I'm sorry.
maybe 7 to 8 minutes. I told you not to make any additional phone calls. You did that. I told you to show up for court. You didn't do that. So pretty much everything I've ordered you to do, you've done the opposite of it. And you sit here telling me that you haven't done anything, when in fact you're before this court on 4 separate cases, including one which is drinking and driving involving a crash. Bond request is denied.
Thank you, Your Honor.
What date would you like to come back? Either November 13th, November 20th?
I think November 20th or November 13th would be best, Your Honor.
You're gonna be ready in a week?
I can be ready in a week. We expect to get that that discovery sometime in the next couple of days, and I will review that with them, and then we will either set these for trial or seek to resolve.
Man, I'm going to trial, bro. Y'all pleading guilty to none of this. It's all absurd.
Well,
And
we
y'all
can
do not
certainly-
find me guilty. Y'all wasting taxpayers' money. I don't care.
Your
what
Honor,
y'all-
we can certainly set these for jury trial at this time. It would still give us time to review the new discovery. If we want to set it for a final settlement conference, it might be best at this point.
Your Honor,
Yes.
I'm sorry, no objection to that. I just wanted to bring up, the court mentioned that also with the last pretrial. Mr. Holly seems to be fixated on one of these cases in particular. The earliest case is a child abuse case involving Miss Sierra Holly, who actually did appear for the final settlement conference. Mr. Bellinger, I hope you have full discovery on that, including the supplemental reports with the photos of her in the hospital and all the CPS attachments that go with that. So we would not be needing to produce her, as well as the fact that she is a minor in the child abuse case and she would need to be produced for trial by the adult that currently has the care of her. So this will not be a case of somebody not showing up.
On December the 16th, 2021, it looks like the witness Sierra Holly was present and excused for future dates. So she does not need to be present. I wrote that in my notes myself.
Okay.
So that one will be going to trial definitively.
I will be found out guilty. Innocent until proven guilty.
All right, Mr. Holly, please be
Innocent until proven guilty.
understood.
Sir, if you keep speaking out, then I'm going to hold you in contempt of court. Any contempt will be run consecutive to any time you have to do. Do you understand?
Yes.
November 16th, 2023 at 9 a.m. for final settlement conference. And December 1st, I'm sorry, that should be 11 a.m. for the final settlement conference. December 1st, 2023 at 9 a.m. for the jury selection. The defendant needs to have proper clothing so that he appears appropriately before the jury on that date. So please make sure that he is prepared for that date.
Okay.
And Your Honor, I will be submitting an amended complaint. There is an error on the case that Mr. Holly is so fixated on with his older son, I believe. And so I was just incorporating, I was going to dismiss that case with the global resolution, but since we want to proceed on it, I do need to make a change to it. So I will submit that to the court as that.
Please submit it as soon as possible so that they can be prepared for the trial.
Will do.
Thank you. You're all set, Mr. Holly, at the November 16th.
This is the matter of Blake Wellman, 2020608.
Good afternoon, Your Honor. Christopher Shemke, bearing behalf of my clients, time to consent to the matter being heard via Zoom.
And sir, your name, please.
Blake Wellman.
All right, and today is the date for probation violation. Your client is currently on probation for disorderly conduct, and it's alleged that your client tested positive for alcohol on October 2nd of this year, which would be technical violation number 3.
Yes, Your Honor, it's the violation. My client will not be contesting that. He will admit responsibility, and we are not asking for a hearing.
Okay. And sir, as the allegation you tested positive for alcohol, how do you plead?
Guilty.
And you understand the possible penalty as a result of your plea today, that would be the recommendation being for you to continue and complete all terms of probation, 5 days jail, increased testing, and probation violation fee.
Yes, Your Honor.
All right, and counsel, if you can please run to your client.
I'd like to take your attention back to October 2nd, 2023. Did you test positive for alcohol?
Yes, sir.
That's right, Your Honor.
Court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation indicate based upon your plea of guilty, technical violation number 3, and counsel, that's the recommendation.
Your Honor, as to the increased testing, no objection. Judge, I saw that it's recommended 5 days in jail. I asked that be suspended in lieu of my client getting a tether for 30 days. Thank you, Judge. Okay,
let's see here. So your client was sentenced on March 17th of 2021. We had a bond, he was HIDA eligible. We had a bond violation hearing April 27th of 2021. And then your client failed to appear for a probation violation on May 26th of 2021. A warrant was issued. Then it was set for probation revocation hearing on August 8th of 2022. Your client failed to appear. September 2nd of 2022, the warrant was issued. September 29th, the court rescheduled your probation violations. You had a different address and apparently didn't notify us or somehow went to the wrong address. So October 17th, the court of 2022, you had a probation violation hearing. You pled guilty, the court revoked HIDA. You had a probation revocation hearing, and the court indicated 30 days tether, house arrest, reinstate probation for 18 months. And your management class was to be registered within 21 days, proof shown, GED, mandatory jail for any future violation. January 30th of this year, there was a probation violation where you pled guilty and this court adopted the recommendation, and the court did not send you to jail, even though the court ordered mandatory jail for any violation. The court increased your testing and continued. That was because you failed to submit to a drug test on January 3rd. Now we have this matter where you tested positive for alcohol. What was it that you were drinking, sir?
That Sunday of, I think it was the 1st or the 29th, I went to my fiance's aunt's wedding and had a couple shots with them there and had a few beers, and then the next day Monday, my color got called, and I knew I wasn't supposed to be drinking, like at the time when I got put on probation, because I wasn't of age, but with my charge having nothing to do with alcohol or drugs, I didn't know that I couldn't drink, so I had a few drinks with them on their wedding day, and then.
No, sir, listen, you're talking on both sides of your mouth right now. You said you knew you weren't supposed to be drinking. And then you tried to justify it by saying that now you're of age, and because your offense didn't have anything to do with alcohol or drugs, that you thought that you could still drink. So it's one or the other. You thought you could or you couldn't.
Well, when I got put on probation, I wasn't 21 yet. When I first started this, back when I first got the charge, that's why I said that. But I didn't know I couldn't drink because of my charge was just being disorderly. I wasn't under the influence when I got the charge, and I'm not a drinker as is. I'm rarely ever drink unless it's an occasion like the wedding.
Well, sir, you weren't supposed to drink, and you knew you weren't supposed to drink. There wasn't any caveat in your instructions that said you're not allowed to drink until you turn 21.
I understand that, but I've been doing everything I can with this probation to get it completed. I did my anger management. I enrolled into school this year. I'm doing online as of right now. I'm enrolled online schooling. I did my anger management. I paid all my fines. I'm trying to be on a straight and narrow path to get this out of the way. It was just a slip up. I apologize for it. I understand.
You went to a wedding. I'm sorry, the day of the wedding was what day?
It was a Sunday. I think it was the 1st.
And you had 2 shots. Or what's a couple to you?
I don't know, maybe like 3 or 4 shots and then a couple beers too. There was an open bar there, so I had a couple shots with them. and then I just had a couple beers to myself. It was all at the event.
All right, well, sir, this court ordered mandatory jail for any violation, and now you have a violation.
I understand. I was just trying to avoid it. I'm a single income household. It's just me, and I mean, my fiance don't work. She stays home with the kids. I do roofing, so I'm a seasonal worker, and we coming close to the end of the season. We're slowing down. I really can't afford it, but I definitely understand if I have to because it's my own fault.
And what is your work schedule, sir?
Monday through Saturday, I start at 7 a.m. and usually whenever the job's done is when I get off.
All right. Well, sir, I'll give you until Friday to report so you can make some arrangements with your boss. Do you have less work next week? I'll give you that accommodation.
I don't know the jobs. I already informed my boss that I might have to go do 5 days because when he sent me the paperwork, so if I have to report, I can report today and just get it out the way.
Is that what you'd rather do, or would you rather wait until Friday?
No, I'd rather just do it today, get it out the way. I already told him. He's already informed about it. My boss, he's okay with it. Like, I'll still have a job and everything.
Okay, well, it's very commendable that you were upfront with your employer. All right, so the court will order 5 days jail. You're going to continue to complete all terms of probation, increase testing upon your release, $50 probation violation fee, and sir, I'll indicate report today. So please email him and Ms. Shaw, and she'll give you those instructions. Okay, sir?
Okay, thank you.
All right, thank you. Have a good day. We're on the record, man of Jeffrey Pringle, 23-25, an appearance, counsel.
Good morning, Your Honor. Mr. Shemke, appearing on behalf of my client, this time we consent to the matter being heard via Zoom.
All right, thank you. And Mr. Pringle, your name, please.
My name is Jeffrey Richard Pringle.
All right, thank you. And today is the date scheduled for a probation violation. You are currently on probation for operating while visibly impaired, and this is alleging technical violation number 3, where it's alleged you tested positive for alcohol on October 2nd of this year. And counsel?
Your Honor, I had an opportunity to review the documentation. My client understands that he could have a hearing in which he could contest this violation. That will not be necessary, but I would like an opportunity to allocate on his behalf.
Sorry, you heard the allegation, correct?
I have.
As to the allegation you tested positive for alcohol October 2nd, how do you plead?
Guilty.
And you also understand that the recommendation here is for you to continue and complete all terms of probation, pay a $50 probation violation fee, 60 days on the alcohol tether, and 15 days jail. Do you understand that?
Yes, Your Honor.
All right, counsel, if you can please write to your client.
I'd like to direct your attention back to October 2nd, 2023. You took a test as a order from your probation. Is that correct?
That is correct.
And you're not contesting that the test reflected and indicated use of alcohol?
I am not contesting that.
Satisfied, Your Honor.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation and the technical violation number 3. And counsel?
Your Honor, I saw the recommendation, no objection to the alcohol tether, but I would ask the 15 days in jail be suspended. I'd ask that he be given one final opportunity to demonstrate full compliance. Obviously, he'll have a tether on. He'll be under strict monitoring. If there's any violations, they will become very apparent to probation immediately. In this circumstance, Judge, I believe the alcohol would be satisfactory admonishment. We respectfully request consideration for this leniency. Thank you, Your Honor.
Sir, what was it that you had to drink?
I believe it was a beer, and that was on September 30th.
Are you going to tell me that you were watching football when you were drinking the beer?
As fitting as that would be for how the prior testimonies have gone, this one was not. I had a moment of depression after I just been laid off work, and I unfortunately slipped up. My safety network of individuals that I reached out to, unfortunately, were not able to respond to me on that particular day. So I've had to make some changes since then.
So you've served jail twice.
That is correct.
On probation.
Yes, Your Honor.
And so your support people weren't available. Did you look for a meeting to go to?
I contacted my AA person. I tried contacting my therapist as well as some family and friends on that particular day.
Okay, I hear what you're saying, but did you attend an AA meeting?
I did not on that day. I am currently working with my mental health counselor to find a different group to meet with. We're still working on that though.
And so are you still participating in the outpatient counseling?
I am.
And so, sir, how much did you have to drink? How many beers?
It was one tall beer, Your Honor.
Sir, let's be honest here, okay? Let's be honest, because at the end of the day, right, you tested positive. It was greater than 10,000 nanograms per milliliter. And this was 3 days after you consumed it. And so it's still showing up. So it was more than one tall beer. What else did you have to drink?
To the best of my recollection, it was only just the beer, Your Honor.
And are you still laid off, sir?
I currently am. I do believe provided all goes well, I should be reemployed for the next week or two.
And why were you laid off?
I was laid off as my position was no longer deemed necessary.
Counsel, I can understand what's going on here. However, your client's on probation for optimal visibly impaired. He said multiple probation violations as why he was served jail time. And it seems to be an every couple month thing. April 26th, there was a violation hearing and he sent the court sentenced him to 5 days jail and then alcohol tether upon release. And then 3 months later, probation violation again for consumption of alcohol, 30 days jail, Wayne County tether. I'm sorry, 10 days jail, 30 days Wayne County alcohol tether. And then now we are here again, 3 months later, and your client consumed alcohol again. I can understand, sir, that it's something that you're working through, but at the end of the day, you're still violating this court's orders, even knowing what it's like when you're in jail.
Yes, Your Honor.
The court's going to order you to continue to complete all terms of probation, $50 probation violation fee. The court's going to order 15 days jail. I'm going to suspend 5. I'm going to serve 10.
I am going to respectfully request consideration for a report day.
Okay. What is it that you're looking, what that you have in mind, counsel?
Sir, how much time would you need to get your affairs in order with the understanding that you'd be going into custody?
I believe I'd be ready to report today if necessary.
Then, Judge, I just asked that he be able to report by the end of the day.
Yeah. All right. And then 60 days on the alcohol tether upon your release. And I will do a jail review on January 8th at 10 a.m. All right. And sir, please email them to Shine. She'll give you reporting instructions. Okay.
I will do that, Your Honor. Thank you.
All right. We have Ms. Lipscomb on Zoom. At one point in time.
She's still here. Miss Linscomb, are you still with us?
Yes, I am.
Okay.
All right, so we can call that.
Yeah, this is case number 23S18805 FH People v. Brianna Lipscomb. Ms. Lipscomb is present via Zoom. Her attorney, Mr. Franklin, is present in court. Today's date and time to address defense motion to withdraw as attorney.
All right, Mr. Franklin, go ahead.
Thank you, Your Honor. I have 2 motions before the court. There's a motion to withdraw. That's due to a breakdown in the relationship between my client and I. I'm also want to argue for a motion to forfeit the right to appointed counsel. So just to begin, the first part of the motion to withdraw. Normally, when I withdraw from a case, it would just be standard to let the court know there's been a breakdown in a relationship, and I typically wouldn't say much else beyond that. But in this particular case, from the onset of the relationship, my client began recording calls that were supposed to be confidential, email exchanges, and then there were assertions put before the district court that I had had no contact with Ms. Lipscomb. And in the same, well, in a different sentence or the same communication, I was let know that she records some of those conversations, which tells me that if I've never had contact with her, how could she record our conversations? So that's just untrue. And so the basis of this forfeiture motion, now a waiver, as the court knows, is a knowing and willing consensual relinquishment of a right, because the founders of this country, they did envision appointed counsel. They knew well the benefit of an appointed attorney, but they never envisioned compulsory counsel, which is why a person can waive many of the rights that the Constitution guarantees. They're not compelled to have them if they don't want them. Forfeiture is a little bit different. It's a knowing and willing engagement in conduct, knowing that engaging in that conduct in this particular case could bring about the loss of representation. That's a possible result if a person acts a certain way. Accusing one's attorney of having no contact when I verifiably have over 22 contacts or communications with my client. Well, that's just part of being an officer of the court is you can't put a lie before the court. So I have to correct that. I've had robust communication with Ms. Lipscomb. I believe our very first conversation lasted over an hour and a half. But what Ms. Lipscomb has done is deliberately begin to fabricate a record, an adversarial record against myself, when initially there was no reason to do that. We just met, I was taking on her case. Yes, she let me know that she's been recording these conversations to use them later, I'm guessing against me. So combine that with the inaccurate statement that I've had no contact with her. We've already covered that's not true. And it's not just that. It's that verifiably on social media, we can see that Ms. Lipscomb has recorded court staff. She's recorded Ms. Woody, the prosecutor, and done all these other things and post these recordings on social media, which tends to frustrate my ability to present a defense. If she's putting out statements, these are statements of a party opponent that can later be used against her. But more than that, it shows that she is taking the court process, and what we see is in the district court, when it became time for trial, that's when the relationship really began to break down. I know in this particular case, there was Mr. Samuels as first the attorney. I remember him citing that there was a breakdown of relationship. I believe Ms. Lipscomb said that he had not had contact with her either. I don't know the status of the communication in that relationship. I wasn't privy to that, but that relationship broke down. Now she is on her second attorney, and I can tell you that it is broken down because I've had communication, but I'm being accused of not having communication. But it's not just two attorneys. So this case, she actually technically went through 3 attorneys. Before this case began, she had the chief public defender, Mr. Downs, representing her on a different case. She chose to record those conversations, which soured that relationship. Before this case even began, she had already burned through 1 attorney at the public defender's office. So there simply is no one else to represent Ms. Lipscomb. I can imagine no attorney who would find it acceptable to have their communications between their client, confidential communications, recorded and then put on social media. Not because the attorney fears that what they say is incorrect, but because it is completely contradictory to representing that client and helping them maintain the right to remain silent. So a change of attorney here, even though there really is no one else to appoint, is not, in my opinion, going to change her behavior. I had a similar hearing in the district court where it was insinuated that the legal decisions that I make are based on race, gender, and other protected classes. I can think of nothing more repulsive to me if that were even true. I spent a long time getting my law license. I went through a lot. There were many slippery rungs of that ladder that I had to climb. And it started in New York City, where it was hard just to get into law school for me. As I went through law school, I had to go through divorce, and that was also very difficult. I contemplated quitting, as many of my classmates did who went through similar situations. However, I didn't do that. I buckled down. I transferred to Michigan State. I came home. I lost my entire social network. I had no support, was in a tiny apartment, and I worked hard. Eventually, I would sit for the bar. I paid for it on my own dime. I passed it the first time. I didn't take a fancy course. I couldn't afford one. I studied on my own by candlelight some nights during the polar vortex. So I know well what the law requires of an attorney. And when someone says I'm not doing my due diligence, that hits me pretty hard. So I don't make decisions based on race or gender. If I'm ever mistaken, I'm absolutely open to being corrected, but I just find that notion to be repugnant and that accusation to be repugnant to my character. So I can tell the court what's probably going to happen here, which is the same types of things that are going to happen at the district court level. As this case gets closer to trial, even if the court were to find another attorney, I see Ms. Lipom is probably going to engage in the same type of adversarial behavior as it gets close to trial. That relationship will break down. And what we see is repetitive conduct that frustrates the normal workings of the court. She has chosen to engage in this behavior. She chooses to record conversations. She chooses to post it on social media. She chose to accuse me of having no contact with her when verifiably I've had over 22 communications with her. She engaged in this conduct knowing it could lose her, this attorney, and it can also lose her, under people for Cameron, the right to appoint a counsel. She would still be free, if the court grants my motion, to procure counsel. It sounds like she's in the process of doing that. She's still free to represent herself. She's still free to take on a pro bono attorney. But as for the right to appoint a counsel, I think her conduct and her abuse of her counsel has risen to the level where she has forfeited that right. And we know that the court can forfeit that. Before the attorney system was set in place in this county and other counties, courts would appoint attorneys on a contract system. And some individuals would go through more attorneys than others. And there usually comes a time when the court would say, without case law, look, if you can't make it nice with this attorney, you're not getting any more. And that's where we are with this case. So I would ask the court to grant my motion to withdraw because there's been a breakdown in relationship. And also, based on people v. Cameron, grant my request for the forfeiture of the right to appoint a counsel. So the court is no longer obligated to appoint the public defender services for Ms. Lipscomb in this particular case.
Ms. Lipscomb, do you have a response, if any?
Yeah, I actually do have a response. What I'll say, one is speculation completely, him saying that I'm recording for the reason of trying to get anyone in trouble or anything and stuff like that. There's no proof behind any of that. I've been recording because, like I told the courts from the beginning, I feel as if I've been lied on about a lot. And at this point, I feel the only thing I can do to really prove myself is record, because otherwise it becomes a lot of he say, she say, and then when in these situations, I'm not really being believed for whatever reason. But I do know that video proof and that recording, that won't, that to me, that's things that it will, you know what I'm saying, I could use for that, and it's no longer versus just a he say, she say. And then what I would have liked to comment to, as far as when I told the courts and them that I had no contact with him, it was me telling them that he has not contacted me by phone, because after court, he had mentioned that we will be in contact once a week and things like that. But during that time, previously, like he said, we did have that 1.5 hour long first initial meeting. And that's when he's referring to when I was recording the conversation and stuff. So that's how I was able to, recording things like that, due to the fact that we did have that 1-hour-long conversation. But once his murder trial stuff had begun, every time, and I have the emails as well, as I'm pretty sure he hasn't to submit to you guys, every time it was time for us to meet and stuff, or have a meeting, he would say something like, oh, I'm still in trial, or I'll call you later, or things like this. And then at that time, I'm not sure if they had the right number for me, because he was also told me like, oh, I tried to call you, but your voicemail's full. And I'm like, this is a brand new phone. There's no way that my voicemail is full. I don't even have a voicemail on this phone yet for my voicemail to be full. So that's kind of what I have to say to that aspect. But I feel a very important thing that he's failing to mention to the court is the fact that prior to this, when we had our initial conversation, he told me he believed he's possibly represented Tickle Properties. And if I ever felt any type of way about that, that I can let him know and he will withdraw. At the court, when I found out that the owner of Tickle Properties was not going to be required to come to trial because he was sick with cancer and stuff, I didn't feel comfortable with that. So I expressed that to him. And he basically was trying to defend Tickle Properties and stuff like that. And I let him know, like, hey, you know what? I don't think this is going to work. Didn't you tell me at any point in time that if I didn't feel comfortable, you would withdraw? He was like, yeah, but we can still work this through and I'll set your case up in a way to where you can get the lawsuits and the perjury and all this. But that's not what I was after. And I kept telling him, like, hey, what I'm after is, I just want my ESA animal. I really don't care for the lawsuits, the money, and, everything else. And he's just like, well, at this point, I can't really help you with that. I'm just going to set you up so you have a very good appeal and a very good blah, blah, blah at the end of all this. And respectfully, that's just not what I wanted. So I understand what he's saying. It's been a, breakdown, but the breakdown started with him and me feeling as if he was defending Tickle Properties. And then I immediately told him, like, hey, I'm no longer comfortable with this. I feel you're not, looking at what's right for me anymore, and I don't want this. And then once I voiced that to him, that's when more of our issues began, because as the case kept going on, I feel as if he wasn't doing what I was asking him to do. And he's like, oh, I'm sorry. He's like, oh, well, I'm only required to do so much by law, and you're asking me to lie, or you're asking me to do this, and that. And it's like, I'm literally, even as today, like, I can literally just ask a simple question and either I'm being ignored, or he's like, oh, well, let me figure this out by the uppers if I'm even able to answer that or assist you with this and stuff like that. So it's like, I understand, certain things that he doesn't feel comfortable doing or want to do and stuff like that. But, when you're what I feel my attorney, if I'm emailing you questions and things like that, and then you're not responding back to him, or you only answering certain things, or you're telling me like, oh, I don't have nothing further for you, but, da, 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 da. And then I'm telling you, like, hey, well, I still have questions. And then it's just being ignored. And then finally I'm being brought up like, oh, you're angry, you're this, you're that. I'm being told that I'm the basic stereotypic angry Black woman and things like that. And it's like, no, I'm really not. All I'm trying to do is, have representation of my case that I feel is fair. And if you had anything to do with Tickle Properties, and these are the people who's making all these accusations against me, and then you're, I don't know. I felt very uncomfortable with the whole Tickle Properties thing with him. That was my whole complaint. And then once I voiced that, like I said, it just literally went downhill from there. It went downhill, and I mean fast. And then
Ms. Lipscomb, can I just put out Mr. Franklin in his motion has indicated to the court in writing that he has never worked for Tickle Properties. Never represented that.
Whoa, that's not the statement that he gave to me. And if you want, you can question him on that. But the statement that he gave to me is that he worked for a law firm and he believed that he may have represented them before. And if I ever felt uncomfortable about it in any way, that he will withdraw.
Well, did you read his motion?
No, I wasn't given the motion until like the Monday before, last Monday, not yesterday, but like last Monday. And my mom's been working with our church family and stuff like that to give me a lawyer. So
he gave you the motion when?
On not this week Monday that just passed, but like last Monday.
Right. So you've had it about 8 days and you've not read it?
No, because my mom and my church family is trying to give me a lawyer, so I was gonna let the lawyer like read it and explain it to me. Because when I tried to, I just didn't understand nothing. Like I opened it and I literally did not understand a thing. And when I need counsel, I don't understand it. I'm sorry.
You didn't understand his motion, which is a written version of what he just said here this morning. And I just let you talk for about 10 minutes and you were countering everything that he said here this morning. So what don't you understand?
How he feels that I don't like what I just said, how he feels that I don't deserve a counsel based on my attitude or things like that. And then he also just stated that I willingly knew or something, that it was basically like make it right with him or I have no other option. Like no one ever told me nothing like that. I didn't have no knowledge of none of that. Like, I mean, just a lot of it I kind of don't understand. Well, maybe I can say it's not I don't understand. Maybe I don't agree. So I'm not understanding. I'm having a hard time understanding because I don't agree with it. In my mind, when I'm trying to process it, I can't because I don't agree with it. Maybe I don't know.
So here's the thing, Ms. Lipscomb. You've indicated to the court several things here, but one of the latter ones here is the idea that you're going to hire your own attorney. Is that what I'm hearing?
Well, my mom and my church family, yes, they are speaking with Mr. Kirkhoff out of Grand Rapids, and I text Franklin earlier today. I didn't have none of the discovery or anything on this case, and he said he couldn't take my case without that. So once Mr. Franklin emailed me that, then I will presume he'll start my case today.
All right, so here's what I'm going to do based on what I am hearing here. There is no opposition to your motion to withdraw. I'm going to grant that. As it relates to the request for forfeiture of her right to counsel, I would note that because she is pursuing her own attorney, that maybe that is a moot issue at this time. Ms. Lipscomb, if you do not, in fact, hire somebody, then you're going to either be representing yourself or we'll have to cross the bridge about forfeiture in the future. Now, I will say this, Mr. Franklin has laid out a pretty detailed and logical request as it relates to current case law that maybe you have, in fact, forfeited your right to appointed counsel because of the way you have failed to work with 1, 2, 3 attorneys now, the actions that you're undertaking. In essence, it's your actions in failing to cooperate and or even one could characterize what's been submitted by Mr. Franklin as antagonistic actions that could be the subject of this forfeiture again in the future. But I hope we don't have to go down that road. And hopefully, Ms. Lipscomb, you will get a attorney and they can represent you and you can go from there. However, we do need to keep our case on track. So do we have anything currently scheduled? Let's just look. And then where's she has that case in district court still, right?
So yes, Your Honor. Actually, as far as I know, on Friday, this past Friday, she failed to appear, and a bench warrant has been issued.
Oh, she's got a bench warrant. Okay.
She was in the hospital, so she is.
Yeah, I was about to say we provided proof I was in the hospital. I was passed out.
She did have a justifiable reason not to be there.
So, well, that raises a couple things here. First, Mr. Franklin, why don't you, if you haven't already done so, just email all the discovery materials that you have to her so she can provide them to new counsel. As it relates to the district court, though, I'm a little confused there. Did this motion get heard there already?
It did.
So she does not have an attorney at district court.
She does not.
I have the same guy as I'm sorry.
Our office was left for standby counsel for the trial.
Yeah. So at this point, I don't know whether, did you also ask the district court for the forfeiture?
And it was granted.
Oh, so you are not the attorney of record. Sure. All right. So Ms. Lipscomb, you do have an outstanding bench warrant. Now, that's up to Judge Vogt how that gets handled and your documentation of being hospitalized, whether he accepts that or not. Those are all issues for the district court. They're not currently in front of me. And so you'll have to get there. It's probably something you want to talk to whoever your attorney is you're talking to now.
Well, the guy in front of you said he was my stand-in and he was going to submit it to the courts and stuff. So I was going to let him handle that aspect of it if that was okay.
But that's why I'm trying to get this cleared up. If, as of last Friday, Judge Vogt allowed Mr. Franklin and that, i.e. the PD's office, to withdraw and granted their motion for forfeiture, they are not your attorney of record. They are not on standby. You're going to have to take care of the district court stuff on your own or through whoever you hire. That's what I was trying to get to the bottom of. As it stands right now, it sounds like there's a valid bench warrant for your arrest. So you need to get that taken care of, or you're going to run the risk of being arrested on that warrant. Now, hopefully we have looked, do we have anything scheduled here for this case?
It's not scheduled.
So why don't we do this? Ms. Lipscomb, I don't even have a docket date in 2 weeks. So I'm going to put this on for status conference on November 28th. That'll give you plenty of time then, if you're hiring an attorney, to discuss with them and give them the discovery materials and be present on the 28th at 8:30 a.m. with you and your counsel. If you don't have one, you're still going to need to be present so that we can keep our case moving forward. And that means either you're going to represent yourself or hire some other person that you are not yet talking to. But let's keep it on for the 28th of November at 8:30 a.m.
November 28th at 8:30 a.m.
Yeah, Mr. Butler.
Thank you.
Are you requesting her to be here in person?
Why are you requesting her to be here?
I think she ought to be here in person. There's allegations of her recording, particularly while on Zoom, and then also
well, I thought Mr. Franklin's allegations were recording your phone conversation serendipitously, like with the with a recorder without your knowledge.
At the forfeiture hearing, she also made some statements that I jumped to the conclusion she might have been Facebook Living the entire proceeding.
Oh, all right. Well, Ms. Lipscomb,
Well, Your Honor, I would like to speak to that.
Hold on. I'm not interested in an explanation. What I'm going to do, I'm not going to require that you appear in person. You can appear remotely. You can appear in person if you like. Just know that there are signs here, and it goes without saying, frankly, you cannot record court proceedings. There is an official transcript if you need to know what happened in the courtroom. Okay, you can order a transcript.
How do I order transcripts?
You contact the court recorder. So either for district court or circuit court, whatever proceeding that you're interested in getting a recording of, you contact the circuit court or the district court for their recorders and request it. There's a fee for that you'll have to pay, but you certainly are welcome to do that. But you cannot record court proceedings.
I have never, and I will not. Thank you, Your Honor.
All right. If there's nothing else, that will conclude the matter.
Thank you. I'll prepare.
Thank you.
Thank you.
We have a record in the matter of Matthew Snead, 23270. And appearance, counsel?
Good morning, Your Honor. Christopher Shemke appearing on behalf of my client. It's time to consent to the matter being heard via Zoom.
Thank you. And Mr. Snead, can you please unmute and state your name for the record?
Matthew Snead.
All right, today's the date scheduled for a probation violation. Mr. Snead was sentenced on April 27th. On April 27th in this matter, and it's alleged, and he's on probation for operating while visibly impaired by alcohol. It's alleged on August 13th, there was alcohol use, and September 19th, Mr. Snead tested positive for alcohol. There'll be technical violations number 1 and 2. And counsel?
Yes, Your Honor, my client's aware that you could have a violation probation hearing that will not be necessary.
All right, and so you heard the plea that your attorney placed on the record, correct?
Yes, Your Honor.
As to those allegations, sir, how do you plead?
Guilty.
You also understand the possible penalty as a result of your plea. And the specific recommendation in this matter is for you to continue and complete all terms of probation. Probation to be extended for a period of 3 months from January 27th. $50 probation violation fee, 30 days on the alcohol tether, attend outpatient, and jail for any future violation.
Yes, Your Honor.
All right, counsel, if you can please pardon your client.
Yes, I'd like to direct your attention back to August 13th, 2023. Did you consume alcohol that day?
Yes, I did.
And then on a alcohol test taken on September 19th indicated use of alcohol. Did you have alcohol on or before that day?
Yes.
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The counsel asks for the recommendation.
I ask they be adopted.
All right, the court will also note that the positive test was September 19th, but somehow Those results were not emailed to us or notified to us by the testing center. Otherwise, sir, you would have been scheduled in court much sooner than today. And sir, here's the concern I have. You were a .21 at the time of your offense that you're currently on probation for. Then on your test from September 19th, you're positive for alcohol. And that was after you had police contact for consuming alcohol and you were .18. So I'm not sure what part of you're not to use any alcohol are you not comprehending?
I wasn't before, I am now.
You weren't what before?
Comprehending the non-use of alcohol.
Can you please clarify that, sir?
So the first charge was for a friend's birthday. I should have never went out. And the second charge, we watched football on Sunday and had a little party.
Okay, I understand that part, but you said that you were not comprehending, but now you are.
Because obviously I drank alcohol in them 2 days, knowing what the consequences were. But now I know the consequences.
So knowing that you have the potential to have probation violations and serve jail time, you still decided to disregard this court's orders and consume alcohol.
Yeah, unfortunately, Your Honor. But I won't do it again.
A lot of alcohol.
Yes, Your Honor. But I won't do it.
Okay. Well, sir, you say that, but here's what I see. You used alcohol on August 13th and you were .18. Okay. You had police contact. Then you still, a month later, continued to drink while you were watching football. So I don't believe you've learned your lesson, and I don't believe that you're not going to do it again. And I don't believe that you weren't doing it between the time you were sentenced and the time you were caught the first time.
Yes, Your Honor.
I understand that there's not a recommendation for jail. However, this court, based upon the allegations, the court's going to order you to continue to complete all terms of probation. The court's going to extend your probation for 3 months from January 27th. So that puts you into April of 2024. The court's going to order a $50 probation violation fee. The court's going to order 5 days jail. The court's going to order 30 days on the alcohol tether upon your release. You are to enroll and attend outpatient. And sir, the court is going to order mandatory jail for any future violations. The court's going to also order an additional $150 in your additional probation costs as well. So this court intends for you to comply with its orders.
Yes, Your Honor.
And if you cannot go in social scenarios without consuming alcohol, sir, then don't go in the scenarios. Perhaps one thing in outpatient counseling that you'll work on is how you can be in those scenarios without consuming alcohol.
Yes, Your Honor.
All right, you're going to be reporting to jail tonight.
Do I turn myself in?
Yes, you're going to email into Ms. Shaw and she'll tell you how you go about doing that.
Yes, Your Honor.
All right, thank you.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed? We're going to start bringing people in person. People are going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No, no.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.